Hi, everybody. Welcome to Probate Administration Tips and Tricks. This week, we're discussing creditor claims. I'm Makenna Hafford. I'm an attorney here at Beresford Booth, PLLC. And yeah, we get to cover kind of those questions you tend to ask of, my parents passed away. Do I have to pay their debts? Am I liable? Who's responsible for this? How do we handle it? So let's get into it. First things first, we always have to establish what is probate. Probate's the legal process when one person passes away. If they own any assets, probate's the court process used to transfer those assets from the deceased individual's name into heirs or beneficiaries' names. A lot of details that go into that, a lot of different ways it can work. But broad strokes, that's what probate is, just the court process to move stuff from a dead person to living persons, peoples, organizations, etc. Probate usually lasts several months. And during those months, there is a process for dealing with debts and obligations of that deceased individual. The debts don't just go away. You still have to deal with them. So every probate, no matter what, or even if you don't do a probate, a thing called a creditor's period exists. The creditor period default is 2 years, 24 months. That's the time frame in which a creditor can come forward and say, hey, I'm owed this money. The deceased individual should pay me back, right? So default is 2 years. There's a process, though, under RCW 1140, where the personal representative of the estate can publish notice to creditors, and we'll get into the details on that, and turn that 2 months into 4 months instead, or sorry, 24 months into 4 months. So the 2 years instead goes to 4 months. Any claims that are filed after are forever barred per the statute, and so the estate's not required to pay them. So I'm sure that right away sounds good. It's kind of one of those no-brainer ones. Majority of people opt to publish just in case there's something out there that's forgotten. This doesn't work on every debt, though. So we're going to talk about that real fast. The type of debt matters a lot when we're talking about the creditor period. There's 2 types of debt really for this. There's secured debts, which are mortgage, car loan, anything where a debt, where the item can be reclaimed if the debt isn't paid. So if you stop making your mortgage payments, your loan defaults, they can come and take your house and kick you out, right? Same thing if you stop paying for your car, same process. I've heard of one with a giant telescope where it was bought on a loan, secured by the telescope, and when the estate didn't pay for it, they were able to come back in and reclaim that property, even though it is after the 4 months, etc. Doesn't matter. Any secured debt can be reclaimed regardless of the creditor period or what the personal representative does during the creditor period. The other type of opposite of secured, unsecured debts. So those are personal loans, credit card debts, or just anything kind of in that person's name. Student loans is another one. Any of those debts are just generally owed by the person, not attached to a specific item. Those are the ones the creditor period deals with, really, right? So secured debts don't necessarily have to be filed. They don't have to go through the creditor period process, but unsecured debts, which are the majority of debts really, are ones that can be dealt with and barred so that by the end of that 4 months, it's not a problem anymore. It's either been paid or it's been rejected and barred. So important to keep in mind. So then we're going to talk about publishing notice to creditors. So this is how you take those 2 years and turn it into 4 months. The statute requires that the notice for creditors, which there's a form example of in our CW 1140-030, if you're interested in looking, it needs to be published once a week for 3 consecutive weeks in a legal newspaper in either the county where the decedent resides or resided, or in the county where the probate was filed. So if you live in Snohomish County, or I guess if the decedent lived in Snohomish County, so mom and dad lived there, mom passes away, and you're working through getting that settled, you can publish notice in Snohomish County, or if there's some reason you can't, you file in King County, or she actually lived out of state, but she owned property here, then you can publish in King County because that's where the probate was open. And regardless of whether it's the 4 months or the 2 years, the personal representative is required to give notice to the Department of Social and Health Services and the Office of Financial Recovery. Oh, their Department of Financial Recovery, and then the Department of Revenue, letting them know a probate's been opened, this person passed away, and you have to send them that notice form directly. So just publishing the newspaper is never going to be enough. You publish in the newspaper, and then you also send that notice form directly to DSHS and Department of Revenue, just to make sure all bases are covered. DSHS is the one that deals with Medicaid, Medicare, all that. So if there's a lien because the deceased individual was receiving Medicaid services, that's why they need it. So that if any property is passing, they get a notice that, hey, this is changing hands. Any money you are owed, you need to come tell us about. If you don't tell us, it's going to move from mom to kids, and you're out of luck if you don't get there in time. So that's the process there. The other piece, and this is where it kind of gets a little more detailed and confusing, is if you are going to publish and shorten it to 4 months, you also are required to send notice directly to all reasonably ascertainable creditors, either by serving them in person or mailing the notice via regular first-class mail. So the reasonably ascertainable creditor would be a, if you know they had a credit card with Visa, you should be sending Visa an actual notice and say, hey, I know they maintained an account with you. I think it's paid off, but here's a notice just in case. And most of the time you just pay utilities, but those are other ones where you could send notices because you know they were a recurring customer there. And so it's just a good way to sort through stuff and go, hey, I know that they died at your hospital, so I'm sending you, this hospital, right, UW Montlake, I'm sending you a notice so that you know, here's where you file, here's how you get your money, here's your deadline. The court just wants to make sure creditors have an opportunity to come forward and are able to make their claim, but they also don't want to leave assets just sitting there until every creditor comes forward. There has to be an end date. So that's the give and take. And then, yeah, the statute defines creditors, reasonably ascertainable creditors, as if the personal representative would have discovered them while reviewing the decedent's correspondence, financial records, loan documents, checkbook, bank account, and income tax returns. So the personal representative is required to sort through any available information that would let them know. You can't look at the mail and go, well, that's a card from Visa, I'm going to throw that away because I don't want to know. Because if I know, I have to send them notice. If you should have known, so if Visa knows they were sending letters and you go, well, I didn't see it, the estate still has to pay. Whether or not the personal representative actually lays eyes on it, is they should have known or should have been able to ascertain that that creditor existed, then they need to be paid and they don't get barred at the end of 4 months. So my slide for that If the personal representative does not send notice to any reasonably ascertainable creditor, the creditor gets either 30 days from when the notice is served or until the end of the 2 years after decedent's death, where they can come forward with their claim, even if the 4 months is ended. So for instance, you have, you're handling your mom's estate here in Washington, but you live in Arizona, you're handling it all remotely, and you don't have a chance to go through her mail, right? You've got her email login, you're keeping track of stuff. You publish notice and it's the end of the 4 months. You come up here to work on selling the house and you go to the mailbox and get everything and you're sifting through it and you see a statement from Visa that you haven't seen before. You go, okay, we need to send Visa actual notice. Then they have 30 days to reply after you mail that notice, even if that's month 5 or 6 of the probate. Or, and going back to kind of what I said before, you throw that letter from Visa away because you don't want to know, because you don't want to get caught. Visa then comes in at 1 year and 11 months and says, hey, no one told us this person who had an account with us died. We've been sending letters to them. And we just found out about the probate, we're filing. You would still end up needing to pay because that was a creditor you should have known about. That's different from if it's someone you shouldn't have known about. So for instance, similar thing of they went to a psychologist that you just didn't know about, never talked about it. They went to this healthcare professional. They don't have any record of it. You never saw it on their bank statement. They just paid in cash when they were there. And you publish notice, you wait the 4 months, and then at month 6, someone files in the probate and says, hey, they went and saw me for mental health services and they owe me $200. That's someone who should have been watching the newspaper and you had no reasonable way of knowing that that person existed. So they're barred and you don't have to pay that $200 out of the inheritance you would otherwise receive. So that's the general process for publishing. Lots of details within that. Some things I wanted to talk about kind of in the middle here that I didn't make a slide for is, how do you know whether you should just pay the claim or whether you should send them a notice? Because you'll start receiving bills after somebody passes away, stuff is still coming in mail or email. So how do you know, do you have to send notice to all of them, or can you just pay them? I kind of get into this a little bit on the next slide with allowing or rejecting. But it's really just better to pay. If you get a bill for $50, you don't want to send them a notice, have them file in court, XYZ. It's probably going to cost you more to send that notice and potentially have an attorney have to deal with it than it would be to just pay that claim. So you are allowed to opt to make the payment even if they don't file. So with that said, what does a creditor filing look like? A creditor has to file within the court proceeding. So you send them the notice that has the probate number. It says, here's the person who died, here's their date of death, here's the court that we're in, we're in King County Superior Court, here's your cause number, and here's the information on how you file, when you need to file, and what happens if you don't file, that your claim is going to be barred, right? So you include all that information, and then it's up to the creditor, right? So Visa or the psychologist or whoever else in your example wants to come forward, and they would file a creditor's claim within the probate, and they have to mail it to the personal representative or give it to the personal representative or the personal representative's attorney. So they have to do both to properly file. They have to let the court know, hey, we're here. We want the estate to pay us this money. So before any heir takes anything from the estate, we want to get paid. And also that they have to send it to the personal representative or their attorney to say, we just filed this, so don't do anything until we're paid. So that's the creditor's response. And then it's up to the personal representative to either allow or reject filed creditor's claims. So, and that can be in whole or in part. You can say, yep, this whole bill's good, or you can dispute it, or you can dispute it partially. Those are your options. So the personal representative should file or should notify the claimant in some way to say, yes, we're going to pay this. We're just, we're going to get to it. We just haven't yet. Or no, this is rejected. And that response needs to happen either after the 4 months ends, or if it's a claim that came in later, right? You didn't know about the Visa bill, you sent them a response, Visa sends back this massive credit card debt statement, and you go, there's no way, like somebody stole the credit card and was using it after death. There's all these payments on it that's after date of death. We're not going to pay all this. You can dispute it at that point, but you need to do it within 30 days after they file their claim. So, and if you don't respond, the debtor can come in and file and say, actually, I'm owed this. I would like a judgment saying that the estate has to pay me back. To be quite honest, I don't see that a lot. Usually creditors file their claim and then they just wait and wait for the estate to get back to them. And they only respond if you reject. Otherwise, they kind of tend to assume it's allowed, they're going to get paid. They don't tend to push for a judgment. Obviously, if it's a contentious claim or it's somebody who is a friend or family member saying, hey, I was owed this money, right? I let them borrow $5,000 to feed their gambling addiction. They owe me. You might receive more back and forth pleadings on that matter. So that takes us to the creditor period ending. Once it ends, the personal representative is responsible for paying off all the debts or rejecting them and going through that process. And that money all comes from assets of the estate. So again, mom passes away in Snohomish County. She leaves a house and retirement, bank account, etc., right? And she's got a Medicaid debt that's got to get paid back. That comes off the top. So you sell everything, it all sits in a bank account. The first person to get a check is going to be DSHS for their lien. You give them the check first, and then you pay any administrative expenses. So that's attorney's fees, court filing fees, etc. All of those things need to get paid too. You make sure all that's final. Whatever's left is what gets divided between the heirs. If there's more debts then there are assets, right? If the estate, you sell everything and you've got 500,000, but Medicaid says they're owed $1 million, you move into a bankruptcy-like proceeding, or you can negotiate with them. So this is where you get a little fancier and you let them know, hey, if this doesn't get reduced, no one gets anything, right? We get moved into this long process. Are you willing to accept less? And a lot of the time, yes, I've seen massive debts completely wiped out or just reduced to like 20% of what they actually were owed, just to avoid going into that bankruptcy proceeding. So if you're managing a probate and you're dealing with lots of different creditor claim, call and ask them, let them know that if all of these debts remain the same, the estate's going to be insolvent. Don't say it's actually insolvent, but it's going to be insolvent. If these aren't reduced, is there any wiggle room? Would they be able to reduce it or waive it so that things can proceed as normal and people can walk away with something? So always good to ask. The other thing the statute doesn't require, but I personally recommend, is if you have a creditor file a claim, DSHS comes forward with a lien, you send them a check for the $500 that they're owed. Get a satisfaction of claim so you have something to file in the probate. Not necessarily required, but always a really good idea, just so it's very clear to the judge, just looking through that all debts are paid, you're done. And that they can't come back and say, oh, we never received anything because someone from the business or the actual debtor themselves signed it and said, yes, we received this check and you're good to go. So that's my last tip on that front. Just cover your bases, make sure you get it in writing, classic lawyer things. And I think that is the end. So any questions, please feel free to email me. And yeah, if you need help with a probate, I'm here and happy to help talk over what you're responsible for, what your options are. Thank you.